Mine, as we say in the court, is a learned opinion, in the sense that it was learned from close observation over a long period of the adverse workings and effects of the death penalty in the justice system. I did not start that way. Early on in my court career, I wrote or participated in 2 cases enforcing the death penalty. One defendant was eventually executed, the other was not, saved by later appeal processes. However, in other cases, it seemed to me that the prosecutors were sometimes overreaching, that some judges were posturing, that deals were often made between the prosecutors and the defense, where some defendants were sentenced to death while their co-defendants were treated much less severely if they saved their lives. Ever present was the dismaying thought that if we were wrong or wrongly led in assessing death, the result to the defendant was irrevocable. I came eventually to the point where I announced on the court that I would dissent in death cases from any further approval of the death penalty. I was vindicated at least once in a case where 2 young men were given the death penalty over my dissent based on testimony against them from an accomplice who received only a jail sentence. Their death penalties were later reduced to life sentences by a federal court, where apparently it developed that the accomplice, the one who had testified against her co-defendants, had engaged in obnoxious relations with her jailer while awaiting district court trial, unknown to the defense attorneys. You can measure in your own minds the worth of her testimony in the light of that background. Now, I want to say to the honorable senators and to the members of this committee what I would say to you if I were visiting with each of you personally. Because I have been a legislator, I too appreciate and understand the pressure you may be under not to support this bill. Your constituents are pounded daily with lurid descriptions of homicides, sound bites formed to get high ratings, and unfortunately the public sentiment crosses over from a sense of punishment to one of revenge. It is very difficult for a legislator, a judge, or a juror to put aside this pressure when dealing with the issue of the death penalty. When you serve as you do in the top echelon of state government, you are shouldered with the duty to view dispassionately how best the state will be served in decisions you make for the good of all. In many of the United States, in fact, throughout the civilized world, the death penalty has been rejected as a punishment too excessive in any justice system. No one can point out any adverse effect in those states or countries from such rejection. I understand that Justice Bill Hunt spoke at the last hearing before the Senate, and I don't know if he's going to be here today, but I think it should be impressive that 2 justices from the court who have participated in death penalty cases now oppose the death penalty. I think that's a matter of impression from the viewpoint of how the law should be looked at.